date, and hence the 14th of April. I must place on record that there is a date for the hearing of the review application, which is the 27th of April, which falls on a public holiday. Yes, I've just shared an email with my learned friend from the court registrar, the High Court registrar, that the senior judge is going to move to the next, for that week, will be held on that very same week. So that situation is clarified. I've shared an email with my learned friend so that he can see for himself. So that application. Now, my clients have always been insistent on me asking this court to strike this matter off the roll. And this is informed by the fact that the search and seizure took place on the 8th of March 2024. And on the 4th of April 2024, just under a month later, accused 1 and 3 launched a review application for the search and seizure. On the 13th of May, which is some 2 months later, the state attorney filed the notice to oppose and the answering affidavit. The matter went on and the pleadings closed in September 2024. On the 7th of November, a call came from the Hawks that they wanted to arrest the accused. I'm going to pause there. Now, this is happening whilst the High Court matter was in progress. Pending, in progress, pleadings closed, about to be set down for a hearing. The accused get arrested on the 13th of November, despite the fact that there was also an urgent interdict that was supposed to be heard on the 14th of November, which was served on the state, was served on the Hawks. Despite that, they went and arrested the accused on the 13th. Even though the matter was to be heard the next day, the very next day, there would have been no prejudice because this matter dates back to 2018, 2019. There would have been no prejudice, but the arrest took place. Now, these events were brought to the attention of the court that the fact that the hearing in the High Court is still pending, it is inevitably going to hamstring the progress of this current matter, which was enrolled whilst the state was aware that there was the review in the High Court. Now, the state argued at some point that the evidence that was seized during the search may be excluded from the trial, and they may decide to proceed with or without that evidence in the event that that review application succeeds in favor of the accused. We don't know how it's going to go. But that being said, it will not make a lot of sense because a search and seizure was conducted, and documents, electronics were confiscated, which we do not know whether the information that was found on those electronic devices forms part of the docket. How will we delineate what was in the electronics versus what the state would say they already had? For them to say, with or without the information seized, we are ready to proceed. Now, there are 2 other review applications which are yet to be heard. We may hear an argument that those other reviews are academic, but the point is that they are pending in the High Court, and the High Court takes precedence over the Magistrates' Court. Therefore, those proceedings has to be completed and concluded before the hearing of this matter. I have an instruction not to agreed to arrange a trial date in this matter until those reviews have been heard. And in order not to burden this court with the appearance and to burden the accused with the cost of appearances, it would make a lot of sense to remove this matter from the roll pending the hearing of those reviews, and thereafter, if the reviews goes the state's way, they know where to find the accused. Through their attorneys or through their addresses, I mean, they know where they live, they know where they work. It was very easy to arrest them. There will be no prejudice whatsoever if this matter is removed from the roll at this stage. However, we're in the court's hands because we've already brought a 342 application which was dismissed, and I understand the reasoning of the court at the time that the matter was not delayed in court. We were anticipating a delay and the Act does not provide for that. But Your Worship would have made a new law by having struck the matter of the roll at that time. Be that as it may, Your Worship, my instructions are that the court should consider striking the matter of the roll pending the hearing of those review applications. One is going to be had a week and a half after the court appearance here. So the accused will come here and a week and a half later will be in the High Court. The problem is, when we come back on the 14th, what are we going to postpone the matter for? Because we do not agree on a trial date. Exactly. We will not agree on setting up a trial date because we will know that in a week and a half there will be a review application that will be argued in the High Court. Will judgment be delivered on the same day? We don't know. If it is, good for us, good for every party. But then there's still other two review applications. So my instructions are to ask for the court to consider striking this matter of the roll. We have, Your Worship, from the date that they were arrested and the date that a 342 application was brought before you, we have now completed a cycle of a year, and there is absolutely no movement in this matter. The charge sheet has been changed a lot of times. The state has got a right to change the charge sheet up until judgment, even when the trial would have started. We know that. But there were charges which were removed from the charge sheet altogether. There's new counsel. The accused are entitled to all of that, we understand. But would it not make a lot of sense if this matter is pended by being struck off the roll? We're not saying withdraw charges. We're saying pend this matter until the High Court applications are heard. Thereafter, you decide what you have to do. Those are my instructions, Your Worship. Thank you. But the 14th of May has been arranged. Oh, of April, sorry, Your Worship.
Just before I go to sit,
Yes.
Mr. Kwashu, I just want to establish from you, when is the date set down for, more especially the review that related to this particular part of the section, before is the date being allocated for the Act?
Not yet, Your Worship, because the recess only the registrars to get dates for all of those other applications. May it please, Your Worship. Thank you.
I have been instructed to place on record, as a matter of record, my instructing attorney, Mr. Ndebele, informed me that there is a matter completely separate of this current matter before Your Worship, wherein a previous employee of SAFA issued summons against inter alia SAFA and other parties. That matter, my instructing attorney is also the attorney of record in that matter. His client is SAFA. In that matter, the matter has been set down for trial in the High Court of South Africa in Johannesburg on the 20th of July this year.
It's only for who the applicant
The plaintiff is a state witness, and the allegations is against, the plaintiff's allegations is that another state witness caused certain actions to be done. So my instructing attorney requested that it be a matter of record that him and his senior and junior counsel will at some point have to have some form of contact, but it would only be in regard to that matter. It relates to an issue in 2010. It has nothing to do with this matter. He's also informed the prosecutor of that situation. I just needed to place that on record, that Your Worship is aware that it is two state witnesses that apparently have, and it's a state witness who has an action against another state witness, and that my attorney appears for SAFA in that matter. That was the only issue I'm indebted. Thank you. Thank you.
Indeed, Mr. Ndebele informed me about the issue of a matter between SAFA and one of the state witnesses, or two of the state witnesses. I will have to look at all relevant issues, facts, legalities, and I promised Mr. Ndebele I'll come back to him with a definite answer as to the way forward, in as far as their request to interview the state witnesses are concerned, Your Worship. So we will deal with it off the record. Now, coming to the issue or issues that were raised by Mr. Nkwashu, indeed the accused was arrested on the 11th, or were arrested on the 13th of the 11th month, 2024, 13 November 2024. However, there was never an interdict that was granted by the court, interdicting the arrest of the accused persons. All we know is that the accused attempted to interdict the state from arresting or from interdicting the SAPS from arresting them. But unfortunately, they could not, they were out of time. Such application was never heard. Therefore, on the 14th, there was never an interdict. And as a result, nothing stopped them from being arrested. So we can not even talk about an interdict because there was none. Now, the accused are again making arguments which were made almost 2 years ago, Your Worship, that the High Court applications will hamstring this court, the criminal court, that before the High Court has given a decision, this court cannot proceed. And the state has always maintained it is ready to proceed with this matter. The disputed evidence obtained through the search and seizure warrant, which is being disputed by the defense, is not the only evidence that the state has and will use in its prosecution of this matter. It is supplementary to what the state has. Its exclusion is not fatal to this matter, Your Worship. We have always maintained our position. We have been ready to proceed with the matter since this matter came before this court. It was always the defense that raised the High Court matters and always brought the allegation and or the dispute that the hearing of the matters in the High Court will hamper the continuation of the matter in the criminal court, and that is not the case. Now the question was, how is the state going to delineate or differentiate between the evidence that was obtained through search and seizure and the evidence that it has? It's simple, Your Worship. Every evidence is recorded. We know when the search and seizure was conducted. We know when each and every piece of evidence in the docket was obtained. All the documents are dated. All the evidence that was obtained before the search and seizure is clearly out of the picture. It's not part of the search and seizure. any evidence that was obtained after the search and seizure, it's its own evidence that was obtained. It cannot be confused with the evidence obtained through search and seizure. We have evidence. Remember, search and seizure is a formal kind of investigation and obtaining of evidence, where every party has to write affidavits, statements, explaining that on such and such a day, a search and seizure operation was conducted. We have statements by all the participants in there. So it is easy to tell which evidence emanates from the search and seizure and which evidence does not emanate from them. So there's no way that we can confuse the two. So that argument falls out in motion. Now, why do we have to remove the matter when the state is saying it is ready to proceed? Earlier this morning when we were arranging the date, I explicitly stated that we should arrange or set the matter down for trial. It was at that time that my colleague, Advocate Fig, raised the issue of a charge sheet that, oh, she's not in possession of the charge sheet, therefore she could not be ready for that. So the state has always been ready. The state was ready to set the matter down, but for the lack of the charge sheet by Advocate Fig, Your Worship. So if we have to remove the matter from the roll, why would we, for what reason would we be removing that matter when the state is ready? The state has been ready. Now, the other High Court application, that is the review application, reviewing Your Worship's dismissal of 342A application, that has become academic, Your Worship. That application was time sensitive, time dependent. At that time, the defense were claiming that the state had unreasonably delayed the matter and the state was not ready. Although we maintained that we were ready, they went on with their application. It was dismissed. Now the review application was made. Today it's a year thereafter. Are they still maintaining that there is unreasonable delay? When we are saying we are ready today, on the 11th of February, it cannot be. So therefore the argument has become moot. It will no longer serve the purpose. I guess one of the prayers is for the matter to be struck off the roll because of unreasonable delays. But are they existing as we speak? They no longer exist, if they ever existed. And I maintain they never existed even before. But then the decision of the High Court would be with regard to what happened a year ago. So it has become just academic. So it cannot hamstring this court. We can proceed with this matter. Now, the last question that was asked by my colleague, Mr. Ngwashi, was, what are we going to postpone the matter for on the 14th? For trial, Your Worship. I'm going to request that the matter be set down for trial. I will be ready with my arguments on the day in question, but he must know that on the 14th, I believe by then, my colleague for accused 2 and 4 would have gone through the charge sheet, we would have finalized the pre-trial issues. And then if that is the case, the only other postponement would be for a set down for trial, Your Worship. And I would advance my reasons then, Your Worship. But for his benefit, it will be for plea and trial. I will be asking for a date for plea and trial on the 14th of April, Your Worship, as a court.
Your Worship, there was a mention of an interdict for arrest. Indeed so. There was an interdict which became moot because the police, despite a directive from a senior judge, which they received the day before the arrest, they went ahead and arrested. Now there is a review application which has been brought for what is called constructive contempt. That review is pending in the High Court against the state machinery who went against the directive of a senior judge who had set down the matter for hearing the next day. which was the 14th, and they went and arrested on the 13th of November 2024, when the hearing was scheduled for the 14th of November 2024, just a day. So we are no longer talking about the interdict. That has become moot because they were arrested and they were in custody. But those actions are punishable in law in the form of a constructive contempt, which is currently pending in the High Court. Now, I will take any instructions. I'll take instructions from my client regarding the 14th of April on what the accused will seek from this court to do. Because obviously, like I've already addressed your worship, we will not agree on a trial date to be set pending the High Court applications. A person cannot simply be slandered, cannot simply be broadcast on national television with search and seizures, and publications are all over the place, just for the state to come and say, we don't care about that evidence. We can work without it. And we have other evidence. Why did you go and search and seize? Searching and seizing is an intrusive method. You could have requested for what you wanted. That could have been delivered if indeed your case was solid before the search and seizure. So the accused did not waste time. A month after this invasion, they went to the High Court to say, we seek relief. This was not done properly. Something was wrong. And I don't want to burden your worship with the reasons why this search and seizure was brought. I can simply mention that some of the reasons were found to be unfounded. So, I'll take an instruction on what steps we're going to take on the 14th of April when the matter comes back before your worship. Because I can already place on record that a trial date will not be agreed upon before the hearing of the High Court review applications. May it please your worship.
So basically, you agree that we can postpone provisionally for purpose of consultation, more especially the advocate has received the amended charge sheet for purpose of consultation, and thereafter we can take it from there as a provisional date, but I'll put it as for consultation.
In principle, yes, we agree. In principle, we agree. Yes, in principle, we agree. There's a purpose. Accused 2 and 4 to consult is if we were to disagree, we'll be infringing upon their rights. So they have a right to go and consider their position, and if there are pre-trial rights that they wish to exercise, they'll be able to do so as a court process.
That is correct, Your Worship.
Alright, on the, I think the item raised by advocate,
those parties, they need to be proper before that court, so they need preparation, so that we need to take into consideration.
Yes, I'm still going to apply my mind as to they are now state witnesses, and they are opposed to the defense team. They're no longer seeing eye to eye. So hence I'm saying I'm going to apply my mind and see how we can deal with that aspect.
Yeah.
But then it's a totally different matter.
Yeah, I'm not going to get into that forum of a civil matter. Let it run its own course. I'm not getting involved there. I'll leave it to the parties as I indicated earlier.